Hi, everyone. And again, welcome to day 2 of Immigration, Equal Protection, and the Promise of Racial Justice, a Legacy of Jean V. Nelson. For those of you who joined us yesterday, hello again and welcome back. And for those of us who are joining us, for those of you who are joining us today for the first time, my name is Raymond O'Dane. I'm an attorney at the NAACP Legal Defense Fund. And I'll say a little bit about LDF, which is a civil rights organization that was founded 80 years ago by Thurgood Marshall to fight against race discrimination in all aspects of American life. And this conference was inspired by Thurgood Marshall, who by then was Justice Marshall, when he wrote his groundbreaking dissent in Jean V. Nelson. Yesterday, we opened the conference by commemorating Jean V. Nelson with some of the people who were closest to the case. We had a wonderful discussion about the way the case was just one part of a broader community-led effort to vindicate the civil rights of Haitian asylum seekers. We also talked a lot about the role of the Equal Protection Clause and why it was important to center race and racial justice in the immigrant rights context even back then. And of course, we talked a lot about Justice Marshall's powerful dissent. The panelists emphasized how that dissent helped to lay the foundation for the work that many of us are doing today. And as I mentioned yesterday, I think that Justice Marshall's really searing life experiences led him to understand that anti-Black discrimination against immigrants was just another expression of the same structural racism that runs through American history. What I think Justice Marshall also understood is something that I think a lot of us also understand, which is that like almost every aspect of American law, immigration law has long been an instrument of racial engineering. And that the struggle for racial justice for immigrants is part and parcel of the struggle for racial justice in America. As I also mentioned yesterday, the idea for this conference grew out of LDF's challenge to the Trump administration's efforts to terminate TPS for Haiti. And many people, I think, were surprised to see LDF, which is a legacy civil rights organization, engage this issue, which is commonly thought of as an immigrant rights issue primarily. What LDF understood immediately, and what Sherrilyn Ifill, who is LDF's Director-Counsel, and he'll be joining us in a few minutes, understood immediately, is that it is unacceptable to afford the government any leeway to make any decisions based on race discrimination in any context. That's long been LDF's position. And that's what LDF emphasized in its amicus, the amicus it submitted in Jean back in 1985. And that position really goes to the heart of what I think this conference is about, which is that too often immigrant rights and civil rights are perceived as separate areas of social justice. This conference is very much about interrogating that and exploring how the Trump administration's unapologetically racialized immigration policies are forcing all of us to grapple with it in old and new ways. As a few of our panelists yesterday mentioned, we also interrogate that idea in the 6-episode podcast series that accompanies this conference, where we talk about some of these themes in more depth. The podcasts are available on our website, and we definitely encourage you to have a listen. Our second panel yesterday also elaborated on many of these themes. And so I'll turn it over to my colleague, Ellie Happel, to say a little bit more about that.
Thank you, Raymond, and work with you. My name is Ellie Happel. I'm Justice Clinic of NYU School of Law. The clinic and Gable North are directly implicated in human rights violations. This has included work in Haiti and ongoing work in Haiti, and also work in the United States. The Global Justice Clinic sits within the Center for Human Rights and Global Justice, which is the hub of human rights research and scholarship, practice, and teaching at NYU Law. And as Raymond said, this conference brings together civil rights and immigrant rights advocates and activists, and aims to build bridges between these communities that are often perceived as separate areas of social justice. Human rights is similarly siloed, and when people hear the term human rights, at least in this country, they may first think of violations and abuses committed by foreign actors, atrocities that happen on other countries' soil. The human rights community must see police killings of Black people, family separation, and the loss of liberty simply due to where you were born, atrocities and rights violations committed on US soil, and respond with similar outrage to those committed abroad. Human rights must recognize and reckon with anti-Blackness, racism and xenophobia, and show up in solidarity for Black lives and for the lives of Black immigrants. This is why I and many of us are here today. And the conversation yesterday really wonderfully teed up the issues and questions that today's speakers and panelists will explore. Panel 2 yesterday afternoon featured attorneys who've litigated DACA, DED, which is Deferred Enforced Departure, and TPS. And the panelists spoke about the difficulty of equal protection claims and yet the limitation of the APA and other procedural claims. And one panelist said, if you limit legal claims to technical issues, you risk erasing the experience of our clients. Panel 2 asked how to move beyond the goal of race neutrality in the law to that of anti-racism and the need for reparations and for transformative justice. The panelists, again, 3 litigators, recognized the limitations of litigation and were an excellent precursor to our conversation today about community organizing and reimagining immigrant and racial justice. My colleague, Sarah Hamilton-John, will introduce herself and say more about what lies ahead today and day 2. And Sarah, it's been wonderful to work with you, and thank you for taking it from here.
Thank you, Ellie, and thank you, Raymond. My name is Sarah Hamilton-John, and I'm an independent legal research consultant. I'm grateful to have worked alongside Raymond and Ellie, who have worked so diligently to prepare this conference. I became involved in planning this conference during my time as a research scholar at the Center on Race, Inequality, and the Law at NYU School of Law. The Center is just one of the many co-sponsors of this conference at NYU School of Law, and I'll just list those now. We have APALSA, BALSA, the Civil Rights Clinic, the Immigrant Rights Clinic, the Immigrant Rights Project, the International Refugee Assistance Project, LALSA, the Racial Equity Strategies Clinic, and the Robert and Helen Bernstein Institute for Human Rights. Our co-sponsors at NYU and beyond NYU include the Center for Caribbean and Latin American Studies, the Gallatin School of Individualized Study, the Latinx Project, the 21st Century ILGWU Heritage Fund, the Haitian Lawyers Association, and the Migration Policy Institute. We're truly grateful for the generous support of all of our co-sponsors, without whom this discourse would not have been possible. Yesterday, we had over 250 attendees, and this number included activists, advocates, lawyers, law students, scholars, and members of the community. And we're so grateful for all of you who joined us yesterday and those who will be joining us today, either for the first time or rejoining us throughout the country. I'll just share some brief introductory remarks before I introduce the first panel. The relentless attack on immigrant communities of color has only intensified in 2020. As the first wave of the global pandemic raged in the earlier parts of this year, the Trump administration seized the opportunity to make unprecedented changes to immigration law and policy, decimating many existing protections and drastically limiting current modes of entry for immigrants to legally enter and remain in the United States. From the gutting of our asylum system to the tightened restrictions on H-1B visas, it seems there are few areas of immigration law and policy that the Trump administration has left unscathed. As immigration activists, lawyers, and advocates zealously support immigrant communities in the trenches, the unrelenting battering ram of xenophobic and racist policies against immigrant communities persists. We truly are in uncharted territory, and the battle continues to rage. Critically, the racial animus inherent in these policies has legitimized hostility and rising hate towards immigrants of color. And specifically, Black immigrants face unique racialized oppression. In just one recent example, a complaint led by the Southern Poverty Law Center and Freedom for Immigrants exposed the abuse and torture of Cameroonian asylum seekers coerced into sign removal documents. The complaint arose amidst the accelerated deportations of Black immigrants. On October 13th, the charter plane carried Cameroonian and Congolese asylum seekers back to their countries. And as Ellie mentioned yesterday, Haitian immigrants have also been on the receiving end of these accelerated deportations, which are often shrouded in secrecy. These very recent examples demonstrate the indifference to the suffering of Black immigrants. The ever-present thread of anti-Blackness in the law serves as an unabated bulwark against equal protection for Black immigrants, and indeed all Black individuals in the United States. At the heart of the clarion call Black Lives Matter that rang so fervently this past summer, we can hear the yearnings of a people seeking to be freed from the politics of Blackness in America. The law has the capability to be a tool in this social and political emancipation, but as with so many other tools, it instead continues to be a systematic weapon of oppression. Even if November 3rd enables the election of an administration that proposes a more immigrant-friendly agenda, the damage created over the past 4 years will take considerable work to undo. It is incumbent upon all of us to reimagine immigrant racial justice. And so today we turn to activists, community organizers, advocates, and scholars to help us think through the existing tools at our disposal, as well as new and creative strategies. We're honored to begin our second day with a keynote conversation with Professor Gemma Solimene, Sherrilyn Ifill, and Dean Kevin Johnson, individuals whose powerful work has transformed both traditional civil rights advocacy and traditional immigration advocacy. In our third panel, we center Black-led immigrant organizations, for it is the lived experiences of Black immigrants that will shape and drive a more inclusive immigrant rights movement. And our concluding panel will explore the solidarity, strength, and opportunities that can be found in coalitions, bridging tools, frameworks, and movements in furtherance of racial justice for Black and other immigrants of color in the United States and internationally. And so finally, before we begin the keynote, I do have some brief housekeeping notes. First, for those who are seeking CLE, Panel 3 has been approved for 1.5 CLE credits in New York State in the areas of professional practice category. All materials, including affirmations and evaluation forms, are available on our website, which is jeanvnelson35.org. But please do note, in order to confirm your attendance, the moderator of panel 3 will share a code before the Q&A that you will need to write down. And if you have any questions about CLE, please email Diane Simmons at dsimmons, so that's DSIMMONS, at NAACPLDF.org with the subject line Jean Conference. And this has also just been posted in the chat. Second, please be aware that the chat is disabled for conference attendees. Please use the Q&A for questions, and we encourage you to post questions throughout the sessions and not just wait for the last 15 minutes at the end. And so without further ado, we are honored to hand the time over to Professor Gemma Solimene for our keynote conversation. So Gemma, Sherrilyn, and Kevin, we ask you to turn on your cameras now, and we'd like to hand over to the conversation, which we are thrilled about.
Good afternoon and good morning to those of you who are joining us from the West Coast. It is truly my honor and privilege to serve as a moderator for this conversation that is sure to be empowering and encouraging and give us a lot of information about what we are facing in these times with respect to immigration and racial justice. And before, of course, I do that, before we get into the conversation, I, of course, would like to introduce these two fabulous and wonderful civil rights activists and scholars and who have been at this for quite some time. I must say, however, that any introduction that I would do in these very brief time that I have would not do the work that they are involved in any justice. But I do want to spend a little bit of time telling you something about them. We'll start with Sherrilyn Ifill, who is the president and 7th Director-Counsel of the NAACP Legal Defense and Educational Fund, which is the nation's premier civil rights organization fighting for racial justice and equality. She is the second woman to lead the organization, and she is my dearest friend. Her work over her career and the awards that she has amassed are far too numerous, as I said, to do justice in the time that I have. So I'll only be scratching the surface. She's been at this work of equality and justice, teaching and lifting up since the beginning of her career. Following her graduation from NYU Law School, where we met, she was a fellow at the ACLU. And before she joined the staff at LDF as an assistant counsel, she litigated voting rights cases there for 5 years. This first stint at LDF was followed by 20 years in the academy at the University of Maryland Law School, where she taught civil procedure and constitutional law, and pioneered a series of law clinics, including one of the earliest ones focused on challenging legal barriers to reentry of the formerly incarcerated individuals. I have to add a personal note here about the fact that I was not at all surprised that Sherrilyn would revel in teaching civil procedure and constitutional law. In our law school classes on the subjects, she was masterful in her command of the material and the ease with which she took on the Socratic method that our professors engaged in. Sherrilyn returned to LDF in 2013 to lead the organization in its work on urgent civil rights issues, which include fighting voter suppression, inequality in education, permeation of racial discrimination, and the many facets in America. She's a powerful voice that is much needed and sought after by government officials, civil and community leaders, and the media. She has received numerous honorary doctorates, and awards recognizing her work, her commitment, her dedication to bringing us to a more perfect union. Most recently, she was aptly named one of Glamour's Women of the Year. We also have with us Dean Kevin Johnson of the University of California, Davis Law School. Dean Johnson is quite honestly one of the foremost immigration scholars of our time. His name is well known in the immigration realm and among law professors in immigration. Dean Johnson is and I apologize, Dean Johnson, I should have checked this with you prior to this introduction, but if I mispronounce this, but the Maybe Apollos Professor of Public Interest Law and a Professor of Chicano and Chicana Studies at UC Davis. He joined the law faculty there in 1989 and became dean in 2008. He has taught an array of classes, including immigration law, civil procedure, complex litigation, Latinos and Latinas in the law, and critical race theory. He is a regular participant in national and international conferences. I tell you that there is not a conference that you will attend where you would not hear that Dean Johnson is sought after as a speaker in the area of immigration law and equality. As I noted, he is a prolific immigration scholar of our time. His books and publications might take your printer and the printer ink might get lost if you try to print all of the publications and articles and books chapters that he has, but I will just highlight a few here. He is an author of Immigration Law and Social Justice, Understanding Immigration Law, Opening the Floodgates, Why America Needs to Rethink Its Borders and Immigration Laws. His articles and book chapters include the intersection of race and class in US immigration law and enforcement, minorities, immigrant, and otherwise. As I said, these just are highlights of the numerous articles and publications of Dean Johnson. He's also, like Ms. Ifill, he's also, he's also received numerous awards and has been distinguished for the work that he does. Latino Law Professor's Distinguished Service Award in 2017. He's received the award for outstanding leadership in presidential initiatives. He served as the immigration policy group for the 2008 presidential campaign of Senator Barack Obama at the time. And he's received Professor of the Year awards from numerous organizations. Without further ado, though, I will turn this over now, move away from the introductions and start our conversation, which, as I noted, is sure to bring a lot to light. Before we begin, though, or as we begin, I should say, I wanted to turn the page to Dean Johnson and ask you if you could ground us in the history of our immigration laws so that we might understand how we got to the place that we are in. We are certainly in some times that are some might say unprecedented, but in fact, if you look to immigration history and immigration history of policies and laws, we might understand how it is that we are in the place that we are in. So if you might just share some thoughts and some time on that, that would be wonderful.
Sure thing. And let me first thank you for that overly kind introduction. I want to meet that person because he sounds kind of cool the way you describe him. And I want to thank the co-sponsors. There's many co-sponsors here. And I'm just pleased as punch to be able to talk a little bit with Sherrilyn, Ifill, and you, Gemma, to discuss these very important issues. And I have to say, when I started teaching, nobody thought that race had anything to do with immigration. And didn't think it was proper to even discuss it or analyze it. So I'm happy to be talking to people that understand that race is front and center when it comes to immigration. And there is a long history here. And actually this is discussed some in Justice Marshall's dissent in John versus Nelson. But the history is the first federal immigration laws were passed to exclude Chinese people from the United States. And they were called the Chinese Exclusion Laws. And they grew out of agitation in places like California and the West, where there'd been violence directed at Chinese, where their labor at once was wanted for the Transcontinental Railroad and then wasn't wanted when that railroad was completed. And there was horrible instances of violence, from burning people to lynching people to chasing people out of town, as well as laws that were designed to punish Chinese immigrants. And this state and local pressure led to the national Chinese exclusion laws. And when the Supreme Court addressed those laws, the Supreme Court said that they were absolutely immune from constitutional review, that whatever the political branches did with respect to the Chinese, and the court said they were more or less despicable, it was okay. There is no room for judicial review. There is complete and absolute immunity from review by the courts. And that started a cycle, really, where there were more laws passed by Congress that discriminated against various groups. It expanded from the Chinese to the Japanese, to the Filipinos, to Southern and Eastern Europeans who are viewed as of a distinct and separate race, and all the way through the 20th century and now the 21st. But Congress is emboldened by the lack of review. And what you have to keep in mind is that the Chinese exclusion case, which is the Supreme Court's important case in this matter, was decided as Jim Crow was arising. And so you have the Chinese exclusion case really grounded in a framework of racial inequality like that seen in Plessy versus Ferguson. And it is grounded in the late 19th century, where whatever you do to people of color is okay, is a constitutional matter. And the important thing to remember is the Chinese exclusion case is still good law. It's never been overruled. It's never been overturned. And it's been relied on many, many times, including in two cases discussed by Justice Marshall in his dissent, one called Naacp and one called Mazzei. And they were Cold War cases where basically one of the people was a lawful permanent resident who went back to the Eastern Europe to visit his mother as she was dying. When he came back, he was excluded from the country. And Justice Frankfurter said, whatever process that Congress gives you is due process as far as the Constitution is concerned. And another case, Naacp, involved a woman who wanted to immigrate here and rejoin and be with her husband, who she had met during the war. The Supreme Court said she wasn't entitled to a hearing, she could be excluded on secret evidence, and there was no rights that were recognized by law. And these cases are founded in the Chinese exclusion case. They're founded in this period of history where people of color had no rights. And so you see this foundation going all the way through to the present, and including in 2020 cases where in the DACA case, the equal protection claim that was made by the DACA recipients, basically that the Trump administration was rescinding DACA because Latinos were affected, it got nowhere in Justice Roberts' plurality. And in another case, it's a complicated one that I won't go into details, but it involves summary removal of somebody who is in the country, isn't given a hearing, and is sent back to his or her homeland. And the Supreme Court said no due process rights can be removed without a hearing, and it was upheld as and it was a 7-2 opinion written by Justice Alito with Justice Sotomayor and Justice Kagan dissenting. So what we're seeing today is very much grounded on the racism baked into the judicial review jurisprudence of the late 1800s that continues all the way to the present.
Thank you. Thank you so much for that, Dean Johnson. So Sherrilyn, you've heard Dean Johnson go through some of the history of sort of how we got here. And the reality is that the government has been given, as Dean Johnson just noted, a lot of leeway, especially in the area when immigrants are deemed to be seeking admission, when they are deemed to be coming to the United States. In Justice Marshall's dissent, while he acknowledged that national origin and can sometimes be a permissible consideration in immigration policy, he noted that national origin, let alone race, cannot control every decision in any way related to immigration. And in his dissent, of course, said that racial discrimination was not to be a basis, right? It was just unacceptable as a basis in immigration policy and roles. So at the same time, however, we have seen and heard, as Professor Johnson said, right, when he started teaching, race and immigration were things that just did not match, right? People did not see them as equal areas to pursue, and that they even had any kind of connection. So what is the role then of legacy civil rights organization like yours in the struggle to vindicate the rights of Black immigrants? Sherrilyn, I think you're muted. Yes.
No, I got it. Thank you so much, Gemma. Thank you for that wonderful introduction. I'm just thrilled and honored to be part of this gathering and really excited to see this conference come to fruition. I want to thank LDF Senior Counsel Raymond Auden, who really had the vision, for this conference. And we were stymied by COVID, but we pressed ahead and made this happen. I want to thank, NYU Law and as our co-sponsors and everyone who joined the first day and who've joined today. And I really am just, I actually could have listened to Dean Johnson just all day. I kind of got caught up. So I just want the Dean Johnson seminar. Because that was just so wonderful and illuminating. And literally, he is a legend in this space and really the authoritative voice on understanding race and immigration. And, I guess I want to begin by just saying that untangling the threads between, race and immigration is kind of almost a fool's errand. But it has been utilized as a way to kind of dodge what I think of as some of the central questions involving race in immigration, and sometimes used to actually suggest something quite different about racial discrimination as opposed to racial discrimination in immigration policy. And actually, when you were speaking, Dean Johnson, and I think you mentioned Plessy versus Ferguson, of course, I couldn't help but think about Justice Harlan's dissent, which is the most powerful dissent. it's seminal. It's our Constitution is colorblind, right? But it's also the dissent that includes that language. But there is a race of people so different from us, and there he is talking about the Chinese, right? So even in the dissent in Plessy versus Ferguson, which purports to suggest that there cannot be racial discrimination and that separate but equal violates the Constitution, there is a reserve placed for a particular kind of discrimination against people that he calls a race of people so different from us. So these webs have been tangled and untangled, as Dean Johnson says, for a very, very long time. And your question, Gemma, goes right to the heart of why I think we wanted to have this conference. When President Trump was elected, a number of us who work in the civil rights and social justice space, as you can imagine, met to talk about what we were likely to face. We were not confused about who this president was, and we were not confused about his racism. He had run on a platform, on an anti-immigrant platform. He had run on an explicitly racist platform, particularly against Latinos, but also against Black people. His history of racism against Black people was legendary and well known. And so we understood that what this election portended, and we all met together at various times. And one of the decisions that we made in those meetings was that we would not allow ourselves to be divided and conquered. We thought the strategy was going to be to embrace some and to shun others. And so we decided that there would be no daylight between us and that we would reserve some of our bandwidth to cover one another, right? To weigh in different ways in the work that we were doing. Now, it now occurs to me that we were naive because there actually hasn't been a divide and conquer strategy. There's just been a conquer strategy, conquer all of you. But that being said, we still executed our vision of covering one another. And so, we were very clear about certain things we were going to do. One of the most powerful briefs, I think, that amicus briefs that LDF filed in the Supreme Court over the last 3 years was our brief in the Masterpiece Cake Shop case. The case involving the baker who wouldn't, bake the cake for the same-sex couple, because we had litigated Newman versus Piggy Park in 1968, the case in which a restaurant owner did not want to serve Black people in his restaurant, but said you could, go out to the back and get something out of the carryout window. And people have forgotten that the rationale offered by the owner of the Piggy Park restaurant was that it was his religious belief that God did not want what he called race mixing of any kind, right? So people had forgotten that religion had been used by segregationists as a rationale for covering their segregationist views. So in that case, we weighed in to, and that was part of our, again, kind of sharing that bandwidth. And so we've been doing that in a number of cases. When the Haitian TPS decision was rescinded, we spent a lot of time talking about that rescission. And look, we were very clear about what was happening. We had been following the president's remarks. He had made the S-whole country remarks. We felt we knew what this was about, but we decided to dig in and find out what was going on. And I'm really proud of the fact that, our client in that case was the NAACP. So LDF is a separate organization from the NAACP. But the NAACP, the National Membership Mobilization Grassroots Organization, also recognized what was at stake. And their members were deeply concerned about the decision. And we decided to file suit in that case because we felt that this case sat at the intersection of race and immigration. And we believe, as a legal defense fund, when we see race discrimination, unconstitutional race discrimination, it's on our portfolio, right? It sits right in our wheelhouse. We didn't feel like this is about immigration and therefore we shouldn't touch it. Now, we don't purport to be experts on immigration law. We are not. But we are experts on the 14th Amendment and the Fifth Amendment provisions against racial discrimination. And so we felt like we're in our place of expertise, and that it was powerfully important for us to litigate this case and talk specifically about what we regarded as the racial discrimination that lay at the heart of that TPS decision, precisely because of the history that you and Dean Johnson talk about of almost using immigration as a way of kind of taking one's eyes away from the repugnant reality of racial discrimination. And this being a space in which courts have provided so much deference to the federal government, then makes it a space where you can allow the worst kind of racial discrimination to happen. When we did the investigation into how the administration came to the decision to rescind Haitian TPS, it read like any other discriminatory decision that would meet the standard of Arlington Heights, Village of Arlington Heights, which is the prevailing case that gives the totality of circumstances test one used to determine whether there is something, a practice that is intentionally discriminatory. It checked off all the boxes, right? It was everything about it demonstrated that there was a very particular view about who Haitian immigrants were. We did think the president's tweets and comments were relevant to the question, but we also thought it was relevant that within DHS, they were particularly trying to develop a narrative about Haitian immigrants that was very particular, right? Asking them to go back and find, and if necessary, almost manufacture evidence of greater criminality of Haitian immigrants, of greater reliance of Haitian immigrants on public assistance. I mean, these are not narratives that are immigrant narratives. These are racist narratives that have been used against the Black citizen population in this country, right? Over reliance on welfare, criminality, and so forth. So the important way, I think, to get the lens right is to recognize that the commonality of that narrative. And one of the ways I think about it is that so much of race discrimination is about controlling the physical presence of Black and brown people in various locations. It always has been, right? The whole concept of segregation is about controlling where you can go, where you can show up, what you can do, what you can touch, where you can sit, where you can go to school, where you can live, right? There is the physical dimension of containment lies at the heart of the way in which white supremacy has been managed in this country. So to me, that is of a piece with the way we think about, or should think about this in the context of immigration policies, that powerful desire to control, to exclude, to detain, right, to pen up, the physicalness of it is real. To exclude, to deport, I liken it to all of the ways in which the physical dignity of Black people in this country has been challenged, and the challenge to that dignity has been at the heart of the kind of white supremacist project in this country. So I don't feel that there is, obviously there's a whole field of immigration law that you are expert at, Gemma, that I am not expert at. But when it comes to the clicking into the activation of those narratives and the covering of policies by the deployment of racist narratives, that I do know. And so the role of a civil rights organization like LDF, therefore, is actually to uncover, right, the game, is to uncover the way in which, the immigration becomes just the cover, the shield, the sheer fabric over something that is easily recognizable to those of us who work in the space. I'm very, very proud of the suit that we filed in the TPS case, very, very proud of the amicus brief we filed in the DACA case, in which we raised the precisely same issues, because I do feel that that's our job, is to actually unveil that truth.
So, there are certainly parallels, right, in the framing in the otherness, right, of immigrants, of people of color, right, in order to sort of have a framing that makes some people feel like it is okay, right? If you alienate, and you, even in the statute, right, immigrants are aliens, right? They are literally aliens. That is the term of art used for individuals who are not US citizens. So even within our statute, right, there's this sort of othering of immigrants. And interestingly, right, you talked about the things that the LDF discovered in its suit regarding the revocation of TPS. And we heard in our first panel yesterday, right, about all of the evidence that was uncovered in the Jean case, right, with what the government was clearly doing, right, was discriminating against Black Haitians. So we now have a situation where there is this body of law in civil rights law and a body of law in immigration, right, that gives all of this deference to the government. But in what ways then might we be able to use the Equal Protection Clause and due process? We heard Dean Johnson talk about the ways in which due process has come in and sort of been kicked out, right? When it comes to immigrants and immigration law, but in what ways might the Equal Protection Clause, which is obviously a centerpiece, right, of legal strategy for civil rights, in what ways might that be able to be used, right? What role can it play in the fight for immigrant rights? Dean Johnson.
Sure, I think Justice Marshall got it right in his dissent. It should apply, and then the question is what it requires. What I fear now is going on is that some of the justices, including Chief Justice Roberts, are using immigration law to water down equal protections for others, including African Americans. I think his part 4 in his plurality opinion in the University of California case involving DACA, it didn't have to be written. There's no reason to write it because they struck down the rescission of DACA on the Administrative Procedure Act grounds. I think that the Chief Justice wanted to water down and actually dismiss at the pleading stage an equal protection claim that in any other context would have legs. This is a program. 90% of the people affected were Latino. And you have a president on record saying, why are we giving relief to all these people from S-hole countries? So I think that one of the fights will be in the future is ensuring judicial review, overruling this plenary power doctrine and the Chinese exclusion case that underlies it. And I think that it's going to take a long time because currently when it comes to immigration, getting a scintilla of review is incredibly difficult. But if we don't change immigration law, I fear that other equal protection claims will be undermined as well in a growing jurisprudence that makes it harder for everybody, not just immigrants, to proceed. And I think that was the goal of Chief Justice Roberts in the DACA case.
Sherrilyn, you were shaking your head vigorously as Dean Johnson noted that decision. Your thoughts?
Yeah, no, I agree wholeheartedly and fearfully with Dean Johnson's analysis of what he thinks is going on. The question you asked, Gemma, was, how can we use the Equal Protection Clause in the immigration context? And Dean Johnson responded by saying the court may be using the immigration context to weaken the reach of the Equal Protection Clause. And I agree with him. And that's a pretty scary project. So there is it's certainly something that I think I am seeing with this Supreme Court, which is it's not just that they are prepared to rule against and find that there was not racial discrimination in particular cases, is that they are signaling that raising the concept of racial discrimination outside of cases in which people use the N-word is actually disfavored, right? We saw it last year, just this past term, in the Ramos case. This is a case involving the use of non-unanimous juries in Louisiana. And Justice Alito writes a whole section in which he says, this case is not about race, right? And really quite disparaging. He's joined by Justice Kagan, by the way, in saying that's not what this case is about. And he basically, says these are people who are poisoning the discourse in this country by making everything about race. That's not what this case is about. Now let's move on to what really matters, right? There's this kind of dismissive tone. Let's go back to the Muslim ban case where we're talking about religious discrimination, but obviously there are racial connections here as well, in which Justice Roberts essentially dismisses the likening of the case to Korematsu, And he says, to go to Dean Johnson's point about, the Chinese exclusion cases never having been overturned, neither has Korematsu, right? But what does Justice Roberts say? This case has nothing to do. Somebody raised something about Korematsu, and that's crazy because this case has absolutely nothing to do with Korematsu. And by the way, for those who don't know, Korematsu has been overturned in the court of history. Now, I don't know where that court is. I am not licensed to practice law in the court of history, but it has not been overturned. And goes on to issue a decision that, frankly, is quite consistent, right, with Korematsu. So there is a kind of way of trying to, and then the DACA language from Justice Roberts is just really scary. So I think that there is a way in which there's an overall project about disfavoring race discrimination claims, period, right? I'm not even going to leave out Shelby County versus Holder, right? The worst decision from the Roberts Court, and there are a lot of really bad decisions from the Roberts Court, but I'm going to put that one at the top, right? And in which Roberts' argument essentially is that pre-clearance under the Voting Rights Act that requires jurisdictions with a history of discrimination to get any voting changes that they want to make pre-cleared through a federal authority, that this is somehow tainting the honor of the South by making a presumption of race discrimination. That is somehow repugnant to suggest that these jurisdictions might be should be held to a standard of special scrutiny because of their history. And of course, we have seen the explosion of voter suppression since 2013, and we have seen how very wrong he was. And he says all this contrary to the record that Congress developed and so forth. So I think this is a tricky time to be answering the question that you asked, Gemma, because I think that we're facing a very dangerous project around race discrimination claims and equal protection writ large. But that said, here's where my non-expertise makes me turn the question back to Dean Johnson, which is, what can we do statutorily in the immigration context to address some of these issues, right? Because I don't know what's going to happen in the election, but let's assume you have a Congress that is inclined towards a veto-proof Congress. Let's leave aside the presidential election for a moment, but a veto-proof Congress that's inclined to take up issues of immigration and there can be marshaled, right, a movement towards addressing some of this statutorily. If you could kind of craft that statute, what would it look like, and what should we be talking about?
One of the odd things in immigration law is that even though the immigration courts that issue removal orders have been criticized for being biased and inept and basically totally partisan, Congress over time has limited judicial review and made it more difficult to even review the basic grounds for removal under the statute. I think part of the project's going to have to be restoring ordinary judicial review to important decisions involving somebody's life and liberty in this country. And that's something that could be done easily. I think another thing that could be done that would change things is to, and actually the New York Bar Association just recommended this in the last few days, but other groups have recommended it for years, creating a separate immigration court systems separate from the Department of Justice, outside the Department of Justice, that isn't controlled by the Attorney General, so that there's more impartial decisions and not biased, slanted in favor of removal in all instances. I think that Congress could do a lot to facilitate and ensure judicial review if it wanted, but it hasn't wanted, and in many instances, it's punished what they call criminal aliens from in ways by preventing and prohibiting any judicial review. And we all know how racially biased the criminal justice system is and who ends up there. And it's no surprise that a Black immigrant ended up in the Supreme Court just a few years ago being deported and detained for the aggravated felony of having 2 marijuana cigarettes in Georgia, where he happened to be profiled on a late night and ended up risking loss of his family of 20 years and being returned to the Caribbean. So I think there's a lot that could be done in real basic stuff. Even, it's amazing to me, even though the criticism of the immigration court system has escalated over the last 20 years, the limits on judicial review have gone up at the same time. And that's just not the way it should be.
So,
Can I
yes,
ask
please.
a question? Just because I'm in all of these conversations about judges, about federal judges, and you know, we all have seen this, and we've all talked about this, and you know, I've written quite a bit about the need for diversity on the bench and so forth. What if I'm in a room where there's a conversation about what's happening with the judiciary? What should I be saying about immigration judges? It's almost like this. It's almost like a kind of, it never gets into the room, into the conversation. And you both. So I'm actually asking you know something about the system of immigration judges. What should we know on the civil rights side? And when we are in rooms advocating around what the federal judiciary, you know, the Article 3 judges should look like, what should we be saying about what reforms need to happen among the judiciary that controls immigration review?
Well, the
so
attorney.
I was going to say, I'm going to turn the floor over to Dean Johnson, certainly, but I do want to just note that as Dean Johnson just referenced, one of the biggest problems is that the Executive Office of Immigration Review falls under the purview of the Department of Justice, right? And so you have the Attorney General, and you know, we know what that's looked like over the course of the last 3 or 4 years, essentially ruling on, right, and having power over how the courts operate, what the courts are going to be doing. And I think a lot of people don't know and understand that it really isn't you know, you can be seen as not being an independent judiciary, right? Because you ultimately will have the Attorney General, right, at a whim, essentially say, no, you know, you're not going to be able to manage your dockets in the way that would render justice, right? We're going to tell you, nope, you can't put cases on, you know, you can't hold cases in abeyance, right? You can't administratively close cases. You know, you have to have these many cases closed by the end of the fiscal year. So it's really quite daunting. It is not an Article 3 court. And, you know, while they are, you know, judges that are supposed to be meting out justice, right, and ruling on the immigration laws, they, you know, sort of have this, you know, big brother kind of looking over and managing the things that they do. But Dean Johnson, I'm going to turn. I'm sure. Oh, Sherrilyn, did you want to add something?
That goes to Dean Johnson's point about the recommendation of moving it out of the Department of Justice to be an independent system. That's helpful.
Absolutely.
Jenna's exactly right. The other part of it is, you know, more than 3/4 of the people appointed as immigration judges by the Attorney General are former Justice Department attorneys who were in charge of trying to remove people from the country. So it's a lot like 3/4 of the judges being prosecutors in a state court system or something like that. And their workload is incredible. They don't have the resources to do it. And it's, you know, some of the most stinging stinging reviews of the Immigration Court and the Board of Immigration Appeals have come from people like Richard Posner when he was on the 7th Circuit, who just said this is a standard run-of-the-mill exhibit of Board of Immigration Appeals ineptitude, or maybe overwork if we're looking at it generously. So we have an immigration court system that's really funded like traffic courts, but they're deciding life or death matters.
So relatedly, Dean Johnson, you spoke earlier about restoring ordinary judicial review, right, in the federal courts, which has been, you know, chopped away significantly over many years. But we've also seen, and this is where I thought you were going to be going, Sherrilyn, is that we've also seen what this administration in particular has been doing with the federal courts, right? And who has been appointed to the federal courts. So how do we reconcile that, right? On the one hand, we have these group of people who will likely be ruling and seeing the law in a certain way, right, and exercising their power, so that even if we were restoring, ordinary judicial review of immigration law and immigration rulings to the federal courts, we might have a body of federal judges that would not be interested to hear these equal protection clause, cases or and the like. So how do we, what does it look like? How do we kind of stitch this up to really have the rule of law, equity, justice come out of the federal courts when we have the judiciary be what it is?
I like you're talking about stitching this up because, it is our legal system that is really wounded at this moment. And we're kind of like out in a field hospital trying to put it together. And so there's no one part of it that has not been damaged and suffered from self-damage as well. And obviously what has happened in terms of the federal courts, is just really shocking. I followed judicial confirmations quite closely. The proffering nomination of judges all coming from one organization, the Federalist Society, that has lists and lists and lists, has made a perversion of the nomination and advising consent process of appointing federal judges, elevating ideology above everything, above competence, above experience. It used to be that being a federal judge was the capstone of a distinguished legal career. Now I think it's today they're voting on, someone who's 33 years old and only practiced for 8 years and never had a client. And, so those are the kinds of people that they have been putting on the bench, which is just bad news across the board, right? For civil rights cases and so forth. And so suggesting shoveling even more sensitive cases before these judges is, as you point out, problematic. And in fact, it's one of the reasons why I've been actually quite exercised. Most people have, obviously, we're all deeply concerned about the Supreme Court. We've all been very exercised about the circuit courts. I've been actually quite focused on the trial courts because, having people who have never tried a case become district court judges, people who have really no experience, is actually quite dangerous. As a civil rights lawyer, we like to try our case, even before conservative judges. And we've had this experience over the last 6 months. We're winning in the trial court because we put our case on and we know how to put our case on and we make our record. Now, when we get into the appellate courts and when we get into the Supreme Court shadow docket, we have not fared so well. But the trial courts are really bound by certain kinds of procedures that, if they are being utilized properly, allow you to make your case. But to the extent we are now increasing the number of judges who have no experience, I think that what we're going to see is cases, a rise in summary judgments and motions to dismiss, because those judges who have no experience will not want to be exposed. You're in open court at a trial. Either you know what you're doing or you don't know what you're doing as a judge. So I'm deeply concerned about that. And that's why what I would just say is we're actually talking about fixing multiple parts of this damaged, system at the same time. I'm not suggesting that, we get judicial review for immigration cases and we shovel them into, our federal system, which is being broken on so many different levels and is in its own need of repair. That's for a different conference. I'm suggesting that all of these things have to happen at the same time. And the reason why I think the immigration conversation is important is because it's not one we regularly have. It really just almost, because of what you all have just described, because of the overshadowing of the Attorney General and the Justice Department, it's almost like people don't really know. And we use this term judges, but we don't at all afford it the kind of support or independence that we think of as what makes a judicial system have integrity. So I just think it needs more attention. People understand what's wrong with the federal courts and know it, but I don't think that people have a facility, a knowledge, and understanding of what's really happening with immigration courts.
So moving a little away from the court system, right, as the means of being able to get some justice, what lessons, might both of you say that the immigrant rights movement can learn from the racial justice movement and vice versa, right? In addition to the things that have been raised, in what other ways might the movements kind of learn from each other, but also continue to work together towards justice for Black and Brown people? Either one of you want to take that first, Dean Johnson?
I'll go first. I'm looking forward to hearing what Sherrilyn has to say. The first thing I'll emphasize is one of the great things to me, one of the great developments has been the growth and emergence of a potent immigrant rights movement. It wasn't that long ago when President Bush said that immigrants lived in the shadows of American social life. And there's a lot of reasons for that, including there were, many immigrants were afraid of getting deported. This new generation, and I can't really pinpoint the precise timing or reasoning for it, but you have had 20 years of pushing for a DREAM Act. You've had protests over December 2005 tough immigration enforcement bill. You have protests, after the rescission of DACA. Now you have protests that are an ordinary course, that are organized and are grassroots, and are thought out. You have not just long-term, civil rights organizations working on this like MALDEF, but you have new movements and new organizations arising. And the way I guess I look at it is that the issues of judicial review and the immigration system aren't going to change because of court cases. They're going to change because of continued political pressure for long periods of time. And that's actually something that I think immigrants' rights movement can learn from the civil rights movement, is that you got to be in it for the long haul. You got to use courts where they can help, but you have to continue the political pressure if you really want change to come about. And so it's a little different for immigrant communities, since there's a portion of every immigrant community that can't vote, but can protest and can do other things. And I have to say, the young immigrant rights activists on campuses across the country, they're fearless. They put themselves in jeopardy in ways that I often think, gosh, they're fearless. I respect that. I hope something bad doesn't happen too. So I think that, as Sherrilyn alluded to, really is you got to be in this for the long haul. This isn't going to happen all at once. We do know elections matter, and hopefully Democrats have learned that filling judicial vacancies is really important, and giving thought and consideration of that is important. It can have long-term impacts. I'm not saying that Democrats should appoint a bunch of 33-year-olds, but I think filling vacancies is a good thing. And I think that it's not going to happen overnight. But when people ask me, and this is a related question, people ask me, when are we going to have immigration reform? Are we going to have immigration reform? I said, yeah, we'll have immigration reform. When? I don't know. It could be decades. Could be a long time. But I know we're going to have it at some point. It's inevitable, given the political pressures, the demographic changes, and the changes in the world, and also young people's different views of borders, I'm using that metaphorically, and immigrants and difference.
Yeah, I feel quite similarly, Kevin. I actually was provoked by the question to actually think about precisely what you said, which was, and it's funny, I actually thought about the in the shadows comment too, because there is a strain of fearlessness that I think is incredibly powerful. I think that, I'm trying to remember the year of the big DACA protest. It was something to behold in the courage of it. And it is the courage that I see of, young activists challenging police violence with, when police are out there with tanks and tear gas and rubber bullets, right? And people are still coming out every night. So I think there is something really powerful that's happening among young people. And the way I'm thinking about it, the way I'm identifying it, circles back to something that you said very early on, Gemma, about the othering. The opposite of othering is belonging.
Yes.
And the desire to belong has been used as a weapon to separate us, right? It separates even within the same community, immigrants against, non-immigrants, right? People have a strong desire to belong, and the forces of white supremacy have used that against us, right? Have used it as a wedge issue between Black and Latino communities, have used it as a wedge issues within Black and Latino communities in terms of citizen versus non-citizen, have also used it with young people in terms of, kind of what they would call respectability politics, but basically, don't you want to belong to the people who are going to be moving forward, who are going to be progressive? You got to protest the right way. You got to be a certain kind of person that, I feel comfortable talking to. And what I see is young people rejecting these artificial entry passes to belonging. And that is where there's real power. Because once you have unmoored yourself from that desire to feel like you are a part of the in group, the group that's going to get the spoils, and you are really fighting for fairness and justice, right? And you're willing even to put yourself in that fight, even though there may be those kinds of consequences. I think you're doing something incredibly powerful. And, I agree with Dean Johnson. My own view is that the greatest progress we make in these areas is when things are firing on all cylinders. And the three things that have to be firing are grassroots activism, very clear litigation, and the creation of a political moment. And when those three things are happening, and those three things actually are happening right now. And so I do see this as a moment in which there is a potential for transformation on a bunch of fronts. It's a window that will close. The question is, what are the priorities that are at the top, right? What are the things that are likely to get the breakthrough? And that's why I think it's really important for us to be engaged in ensuring that we're breaking down artificial walls between our work, so that it's not like some people get something and some people get nothing, right? And that we begin to really, really push back against these narratives that are so useful, right, in creating these separations. I think this is the time to be doing it, because I think there is potentially a moment for transformation ahead, but it is not a moment that will last forever.
Can I add just a little something to that?
Yes, of course.
It strikes me in that what we've been seeing, and I think it affects protesters, it affects immigrants, the rhetoric of dehumanization that helps justify we can do whatever the heck we want to do to those people because they're not even people. They're animals. All the Salvadorans are MS-13 members and they're animals. Mexicans are rapists and criminals. The Blacks do this or they do that. And I think that one of the things that is important is to emphasize that, and I always say it, I try to always say it, these are real people and real people's lives who are affected, and they're hurt and they're injured and they bleed and they cry. And I think people got that when it came to family separation, and they saw the picture of the little girl being separated from her mom. Even Joe Biden can understand, that's powerful stuff. And I think that we really have to work hard to humanize the people who are affected in the face of people like, Stephen Miller and Donald Trump, stripping away their humanity at every turn.
And it's very dangerous. Yes. It's very dangerous. It's very dangerous. I'm one of the most powerful, moments was after the El Paso shooting, and the way in which the civil rights community came together. We were down in DC the next day, standing, Maria Teresa Kumar, Vanita Gupta, and me, and many others, just to demonstrate, that we saw a common danger. And the language of dehumanization that Dean Johnson points out is I don't think we've adequately accounted for what a dangerous moment we are in this country, because we have become inured to some of it. Last night, the president talked about people being low IQ who return for their hearings in court, immigrants who return for their hearings in court. And we just keep it moving, right? Not like that's a groundbreaking moment of just something so vile and so repulsive. So the truth is, we have actually kind of allowed some of this to happen in a way that doesn't produce a reaction really anymore. And that gets very dangerous. Because what you can do once you have deployed a lexicon of inhumanity and it has become internalized in the society, is that it does open up people to tremendous danger and vulnerability. And we're seeing that with the rise in hate crimes and the greater anti-immigrant language and sentiments and so forth. And so we shouldn't take that off the table. That is relevant to this entire conversation, because we will need to confront that. And that is a process that, when you unravel that a little bit, it's really, really hard to get to move forward again. So you have to attend to it. And at our peril, we attend to all of the other pieces, the law, the courts, the statutes, all of that. And we don't attend to the fact that this poison has been introduced in a really, I don't want to say introduced like it didn't exist before, but I mean introduced in an extremely lethal form, and a very dangerous form over the past 3 years. And that's some of, we're having this conversation, and both Kevin and I have referred to the remark about S-hole countries, right? So, we're talking about language that is really, really toxic. And that is part of this as well, that has to be addressed. And that's that goes to the core of of civil rights, right? Which is about the dignity, of people, particularly racial minorities. It is about our not only our citizenship, as we talk about citizenship in the formal sense of, Black people being citizens of this country per the 14th Amendment, right? But also it is about human dignity. It is equal protection of laws for all persons. All persons are entitled to equal protection of laws, not all citizens. And so I do want to make sure that we're attentive to that danger that threatens to undermine this entire project.
Yes, toxic and blatant, right? Really outrageous. One of the things that struck me, that I just want to sort of make note of, that seemed to be a common theme before we turn to our questions, is the power of information and education, right? And I think the role of social media, right? The role of just the media, right? I mean, just as we saw in the civil rights movement, right? When you look at people, right? It's hard to turn away and not recognize that, wait, there are dogs and fire hoses, and people are just getting clubbed, right? And all they're asking for is fairness and justice. And I see something similar in the immigration movement, right? Where individuals are able to look and say, okay, but wait, the bottom line though is that this is not good, right? There's something that's just, we say sort of, this is not us, right? This is not who we are. But there is something to that. And I think in many ways, the grassroots activism and how we can use the power of images, right, to bring these issues to the forefront, certainly can help. But now it is time, since we do have limited time. I could talk to you here and listen to you guys for forever here. But we do have many questions that I'd like to at least hopefully get to most of, if not all of. And the first question is for both of you. And the participant asked if you can talk about the specific ways that anti-Blackness operates in the immigration space. Right, Dean Johnson, certainly you can address that, and Sherrilyn, if there's anything you'd like to add to that to answer that question, that would be great.
I think that anti-Blackness functions in the immigration space just like it functions everywhere else in American society. I mean, in terms of the immigration system, the primary source of removals is the criminal justice system. So that, you know, people come in through the state courts, they end up in the removal machinery and get deported from the country. And as I said before, it's African Americans and Latinos who are primarily the targets of state and local law enforcement. And I think the case that I mentioned before is called Moncrief, involved you know, somebody who was pulled over for a small amount, possessing a small amount of marijuana in a rural highway in Georgia, and then ended up facing deportation. I think that's one place it plays out in the criminal justice system. I think you see it you know, in efforts, not just in Sean versus Nelson, but efforts over decades to keep Haitians out of the United States. And Haitian interdiction policy, an extraordinary policy that went up to the Supreme Court, and the Supreme Court upheld, basically saying that interdiction was within the foreign affairs power of the US government. I think that we see stereotypes of all sorts come up into play in immigration matters. There's a lawsuit a few years ago where there was a informal manual in the Rio de Janeiro office of the American consulate that said that tough-looking Black Brazilians should get extra scrutiny because they're probably engaged in fraud of some sort. And there are also stereotypes that are in effect codified in State Department manuals in many African nations, including Nigeria, saying that Nigerians aren't ordinarily truthful, so you really have to press them, things like that. So I think that you see, racism against African American, Africans play out in the immigration system, just like you see it played out in American social life.
Yeah, I mean, I'll just add before we turn to Sherrilyn that, over the 20, 30 years that I've been doing this, so many of my clients sort of can't really grasp and understand how it could be, right, that they could be separated from their families after having lived in this country for decades, oftentimes, coming in as infants, right, or teenagers, right, being educated here and working here, for a mistake that might have been made in their 20s, right? It's just like, well, wait, and there's no statute of limitations, right? So something that someone did 20, 30 years ago can now be brought, right? So they take a trip abroad and they come in, they take a trip abroad to go on vacation, right? And they come in and like, oh, we had a wonderful vacation. And they're stopped at the border, they're stopped at the airport to say, oh, so you had a problem with the law 20, 30 years ago? Like, yeah, like, okay, so now we're going to deport you for that. Right, so there is really this, this kind of disconnect. But since the criminal justice system, as we know it, right, affects Black and Brown people disproportionately, right, that anti-Blackness and immigration policy and effect on immigrants certainly comes in. But Sherrilyn, I did want to give you an opportunity to answer that question.
Yeah.
So
yeah,
yes.
Not much to add, except I think there was probably no more stark example in American immigration policy than the difference in how Haitian asylees were treated versus Cuban asylees. There just isn't any more stark example. It was very clear what was happening. And so I would encourage people to kind of, now I realize that many of the people watching may be too young to remember the kind of heart of that period, in the 80s in particular, and early 90s. So to understand the difference between how those two populations have been treated by our immigration system is, to me, Exhibit A. I also, if I could, I'm not able to do it, but I would put the link to our complaint in the Haitian TPS case in the chat, and maybe somebody can make that happen so that that's available. Because when you read it, you know, if I took out Haitian, you know, they're just talking about Black people. You know, every narrative they were trying to create to justify rescinding TPS status would be very familiar to anybody who understands the anti-Black narrative in this country, right? So it was about criminality. It was about, you know, being welfare queens. You know, it was about the undesirability of these people in your neighborhood. All of that stuff that we are familiar with, that is part of the anti-Black lexicon, was deployed and utilized, and at least sought to be operationalized in the TPS rescission. So it's there, very, very presently there, and easy to see if judges are willing to see it. And, you know, as we've been talking about, they are often not willing to see it.
So another question that we have is, how do you suggest engaging African Americans in advocacy about immigration issues? Right, and
yeah, let me say something brief. Yeah, I'll say something brief about this. It goes back to the comment I was just making earlier about belonging and getting caught in the belonging trap, right? And I think this is something that we have to be very careful about, you know, but I'm a citizen, you know, you are Black, okay? And if you know anything and have watched any video of an innocent Black person being killed by officers of the state, then you should understand that we are citizens, you know, sometimes formally, but not in the full sense in which that language was meant to be operationalized in the Equal Protection Clause. Just a moment here on the Equal Protection Clause in the 14th Amendment, right? The first line of the 14th Amendment grants birthright citizenship. So citizenship to everyone born or naturalized in the United States. And the purpose of it is to give Black people citizenship that had essentially been taken away by the Dred Scott decision, or at least any claim to citizenship had been taken away by the Dred Scott decision. Now, a lot of people say it was to give formerly enslaved people citizenship. No, all Black people, because remember the Dred Scott decision purported to take away the citizenship of free Black people as well. You know, Black people had no rights that the white man is bound to respect. So the first line of the Equal Protection Clause is designed to try and to ensure that Black people are citizens. Now, there is a legal term, you know, citizens, and that is true. But like our whole quest since 1868 has been trying to actually make that real. You know, what are citizens entitled to? They're entitled to, you know, the full protection of the law. They're entitled to be treated in certain kinds of ways and so forth. And yet we've been fighting that battle since 1868, once we had the language in the 14th Amendment. So imagining yourself to be in some exalted position, right, when that has been our struggle, should tell you something about your citizenship status. And then, as I said earlier, in that same 14th Amendment, the guarantee of equal protection of laws is guaranteed to all persons. And when I say this, can't tell you how many times I go out and speak to people and I say this, and people are like, what? Yes, not just to citizens, all persons. So if you are within the borders of this country, you are entitled to equal protection of the laws, whether you are a citizen or not. And that's the language of the 14th, for those who are originalists and textualists, that's the language of the 14th Amendment. So the idea that you can you know, somehow sanction discrimination, racial discrimination in particular, against immigrants, you know, flies in the face of that. They too are entitled to equal protection of laws. And so I just think we need to just be fully in touch with the fragility of our own citizenship as African Americans who are citizens in this country, but also understand that those who are immigrants are also entitled to equal protection of laws.
Dean Johnson, anything you want to add?
I defer to Sherrilyn on this. I'll mention 2 points though, quick. When Attorney General Jeff Sessions said that if all the immigration enforcement measures were successful and put into place and the courts didn't interfere, then Black people would be better off. They earn more money and they wouldn't have competition with immigrant workers. I'm not convinced of that. I think it's worth thinking about that. The Trump administration has really tried to pit African Americans against Latinos when it comes to immigration. And so is the president as well. And I do think that there are a fair number of common interests that could be pursued in fighting the criminal justice targeting of Latinos and Blacks in cities across the country, because it also often goes hand in hand, the same rationale, based on statistical probabilities and things like that. And that seems to me a place where people of good faith could work together.
So before we get to what might be the last question, given our time, I just wanted to make a note that Sherrilyn's request has been granted, and the LDF's complaint in the Haitian TPS case can be found in the chat. So there's a link to it there, so please, get to it that way. So there is another question that has come in. That very interesting and very good question, I think. And that is, as there has been the defund the police efforts, there are also the Abolish Ice protests and efforts. In what ways do you see these efforts coming? In what ways do you see these efforts can come together with respect to strategy, messaging, and the like?
I don't have a good answer to that. Maybe Sherrilyn does.
Okay.
Very quickly, I would just say what they have in common, which I think is really important, is that they both question the inevitability of oppressive structures, right? Which is that people just, when people first started saying, activists first started saying defund the police, there was a visceral reaction among many that, oh my God, that's just, it can't be, that's outrageous. They've gone too far. I was with them, but now I just can't be with them. And then there was a conversation about like, well, what does this mean? How much money does law enforcement get out of the budget? What exactly do they do? What percentage of their time is spent responding to violent crime? How much of it is spent responding to homelessness, people who are mentally ill, youth violence and conflict, and so on and so forth. And once you got deeper into it, then people started to say, well, wait a minute, maybe now I can get it. Yeah, because even police officers will say, we're not social workers, right? We don't want to have to respond to mental health issues and homelessness and so forth. So then there is a richer conversation about what kinds of decisions we want to make about public safety and whether or not the way in which we have received it is the only way. And why can't we be bold and think about a different way of imagining the structures of public safety, some of which would include certainly some form of response to violent crime, some constabulary, prepared to respond to violent crime, and even then within the bounds of the Constitution and with an understanding that racial discrimination is never permitted, and with controls and guidance around use of force, and with professionalism and training, and with recruitment of people who have the kind of maturity and mental health stability and moral soundness to engage in that work, right? But also with these other elements that are not law enforcement, that we could fund and beef up to expand, mental health support and youth support and so on and so forth. The Abolish ICE conversation is actually the same. I think for many people, they have only been conscious in a time in which there has been a Department of Homeland Security. Right. But the three of us know that for most of our life, there was no Department of Homeland Security. This is something that was created after 9/11, right? And funded like crazy, a whole cabinet position, right? And I think that, and the creation then of this force, right, that kind of operates also, again, not really in a coordinated way, but kind of it has a kind of a political sense to it and can be kind of deployed as the president's own force and see themselves in certain kinds of ways. I mean, that this too has just been kind of received as inevitable. But when you begin then to probe, you start to say, well, we didn't always have it. So do we have to have it? And if we didn't have it, isn't it time for us to reimagine how we deal? Every country has borders. Of course, there are borders, but how you manage those borders, how you engage with people who seek to cross the border, the laws and the responses that you make to people who seek to enter those borders, the rules that govern how people are treated at the border, all of those things are creations that we can recreate anytime we want to. And so I think what joins these two together is, that it really challenges us to face that some of these things that we have, structures that we have found to be and we know to be discriminatory, but that we have accepted as being kind of inevitable in their current formation, are not inevitable, and they can be transformed. And so they both emanate from an extremely powerful and ambitious place of visioning a future that ambitiously seeks to engage issues of racial justice at a structural level.
Yeah, and certainly the prioritization, right? I mean, what is being prioritized, right, for the enforcement of laws, right? There's certainly a connection there also.
Kevin, what do you think about that? Kevin, what do you think about that? Am I wrong?
No, I agree, but but maybe you're more optimistic than I am. I think it's going to be a lengthy and challenging discussion that's going to be incredibly hard. And thinking more from the immigration side, because I'm more familiar with that, people can agree on, tearing down this immigration system and enforcement machinery, but coming up with a new one is going to be a hard one to discuss. And just getting people on the same page when it comes to, incremental immigration reform is incredibly difficult. So I think these conversations, you mentioned they'd be challenging. I agree wholeheartedly there, and it is going to take a lot of hard work by a lot of dedicated people.
Well, we have come to the end of our time for this riveting and engaging and energizing and very important and informative conversation. It was truly a pleasure to moderate it, and it was very easy to do with these two esteemed panelists that we had. I thank you, Sherrilyn Ifill. I thank you, Dean Johnson, for your work and for your wisdom and for all that you shared with us today. Enjoy the rest of the conference. It's my understanding that the next panel starts at 2 o'clock. Wonderful to be a part of this.
Thanks for the honor.
Thank you. Thanks so much.
Thank you so much, Gemma, Sherrilyn, and Dean Johnson. We're so grateful for that incredibly riveting conversation that we just had. It was a perfect way to begin the second day of our conference. We'll now take around a 12-minute break. And as Gemma said, we will resume at 2 o'clock for our third panel, which is the state of immigrant communities of color, racial injustice, and community organizing. We look forward to seeing you then. See you at 2 o'clock.